Hello, this presentation is on trademarks for real estate investors, and you can download the slides to this presentation at www.tpf.legal/we-kill-houses. And yes, I use the phrase "we kill houses" in my hypothetical trademark that I'll be using in this presentation. And my name is Brian Pendergraft and work at the Pendergraft Firm, LLC, where I primarily practice real estate law in Maryland and DC, but I can assist real estate investors with trademark registrations nationwide. Disclaimer: this is legal information, not legal advice. For legal advice, contact an attorney. I highly recommend consulting with an attorney before applying for a trademark. What do trademarks do? Trademarks help protect your brand, they protect consumers from being misled, and they help consumers associate your goods and services with one another and your brand. What trademarks don't do? Trademarks do not protect the original literature of the real estate course. That's what a copyright does. They do not protect your cool real estate invention. That's what a patent does. And they do not enforce themselves. That's what legal action does. The difference between a registered and an unregistered trademark. A trademark does not have to be registered with the United States Patent and Trademark Office in order to be valid. Trademarks are based on first in time, first in use. So in a sense, you have a mark the moment you begin selling a good or services with its own unique mark. However, enforcing an unregistered mark is incredibly difficult. By registering a trademark, infringers have the burden of proof to prove that they are not infringing on your mark, as opposed to the other way around. A registered mark has nationwide protection. An unregistered mark may only be protected in a certain region. Registered trademark holders can also get significant monetary damages against their infringers. And also, you can upgrade from the TM, from having TM next to the mark to the R sign, to the R, which means that your mark is federally registered. Here is a hypothetical trademark problem that having a trademark can help solve for real estate investors. So say there's a real estate investor coach named Bob, and he starts a Facebook group called We Kill Houses Full Time and trademarks the phrase We Kill Houses Full Time for educational purposes. He kicks out a member of the group for trying to sell his own coaching services. The group member is angry and starts his own group to sell coaching services called We Kill Houses Full Time Uncut. People are confused and think that the groups are related when they are not. Real estate coach Bob enforces trademark to make the new group change its name. Before filing for a trademark analysis. So applying for a trademark is relatively easy. The hard part is doing the analysis beforehand. I find this to be true of law in general. Question 1. Are you willing to enforce your mark? Having a trademark does not prevent others from copying your mark. If someone uses your mark, you can use tools such as takedown notices, cease and desist letters, and ultimately litigation to get them to stop. But litigation and legal action can be very expensive. Question 2. Are you actually using or intend to use your trademark? You must actually use your mark in selling a good or service and submit proof. In an in-use trademark application, you must submit the proof at the time of filing your application. In an intent to use application, you must submit the proof at a later date, and there is an additional cost to submit it at a later date. Nevertheless, you must eventually actually use the mark, or it will be denied. Question 3. What classes will your trademark be? There are 45 trademark classes. Classes are categories of goods and services. It costs a minimum of $225 per class, and many marks need multiple classes. For example, if I wanted to sell We Kill Houses t-shirts, if I wanted to sell We Kill Houses educational products, they're actually in 2 different classes. So that's at minimum $225, for each class. So as you can see, the prices can add up. Question 4. What is your budget? For smaller budgets, consider a standard character mark. A standard character mark protects a word or phrase no matter how it is displayed. Standard character mark for We Kill Houses will prevent competitors from using the phrase in their logos, shirts, etc. But if you have a Coca-Cola budget, consider going full Coca-Cola and trademarking everything related to your brand. Question 5. Is your mark distinctive enough to trademark? There are 5 levels of distinctiveness, ranging from generic, the least restrictive, which cannot be trademarked, to fanciful, which is the most most distinctive and easiest to trademark. So example of and then there's everything in between. Here's a generic example. I have the real estate firm. That's so generic you probably cannot trademark that. There's descriptive, which describes the mark, such as frugal real estate investors. And again, this will be very hard to trademark, but it is trademarkable. But as a general rule, you want to aim for suggestive or higher. This requires a little bit of imagination or thought to know what it means, such as using the bird doggers for a real estate firm. The entire arbitrary is using strawberry to sell real estate, just like Apple uses Apple to sell computers. And then there can be something that's completely made up or invented for the purpose of a mark, and this is called fanciful, such as my trademark, which is planlord. Again, as a general rule, you want to aim for suggestive or higher, and some marks may fall into multiple categories, such as we kill houses, which is a little bit suggestive, a little bit arbitrary, and maybe even a little bit fanciful. For questions 6 and 7, is your mark too confusingly similar to an existing mark? And are you the first person to use your mark? The United States Patent and Trademark Office will reject your mark if someone is already using it or if it is too similar to an existing mark. One of the things you can do to see if someone is using the same mark as yours is to do what is called a direct hit trademark search. You can search your word or phrase using the United States Patent and Trademark Office, a trademark and electronic search system. You can Google USPTO test search to be taken to where you can do this search. The positives, this is free. The negatives, this will only tell you if someone has registered the exact same mark. This will not find every instance of confusingly similar marks, and will also not search outside TES to see if another business is using it. It's an inconclusive search. The better option is to use a comprehensive trademark search and attorney opinion. A comprehensive trademark search and opinion is the intellectual property version of a title search and opinion. Multiple permutations of your mark are searched in multiple databases to discover if the mark has been used, and an attorney can give you an opinion on the marketability of your proposed mark. Just like you should always get a title opinion before buying a house, I recommend getting a comprehensive trademark search and opinion before filing for a trademark. Contact me if you need a trademark search and opinion. Applying for your trademark. Once the application analysis is done, the hard part, applying for the trademark, is relatively easy. It's fill in the blank. You must also upload your proof that you're actually using the mark if you do or use the 1B application and submit that proof later. And here is the link of where you can apply for trademarks. Deciding the application type. There's multiple application types or trademark application types. I prefer TEAS RF, which is TEAS reduced fee, and TEAS plus. TEAS RF reduced fee costs $275 per class, must be done entirely electronically, and you can come up with your own trademark description. I recommend using an attorney to increase the likelihood of your description being accepted by the United States Patent and Trademark Office. That should say PTO, not TPO. So, example of a TEAS reduced fee description. This mark consists of the Western persona. This is for the We Kill Houses logo. This mark consists of the Western personification of death holding a scythe next to a house. TEAS Plus application. This costs $225 per class. This must be done entirely electronically as well, but you must use a pre-approved description. So this may not necessarily encompass everything that you want your mark to do. Here's sample TEAS Plus trademarks for real estate investors. For a real estate investor looking to sell a book, printed pamphlets, brochures, manuals, books, booklets, leaflets, informational flyers, informational sheets and newsletters, adhesive back stickers, and kits comprise solely of one or more materials in the field of real estate. For real estate investors looking to sell an ebook on a website, downloadable documents in the field of real estate provided via website. Deciding on a 1A in-use or 1B intent-to-use application. In in-use, a 1A application, you must submit the proof that you are using the mark at the time of filing, and proof must be submitted for each and every class. In an intent-to-use 1B application, you must submit the proof within 6 months of the application or ask for an extension. To submit the proof later, it costs $100 per class, and to ask for an extension costs money as well. Example proof for, let's say, for We Kill Houses print products, a picture of the We Kill Houses book should be sufficient proof. Trademark approval or denial. It takes about 6 months for your application to be processed. If your mark is denied, you'll be given an opportunity to respond as to why it should not be denied. If denied, consider hiring an attorney to respond. Trademark maintenance. You must renew your trademark in between 5 to 6 years after it has been registered, and successfully renewed applications are renewed for 10 years. Trademark classes relevant to real estate investors. Paper and printed material products. Say, for example, I want to sell the We Kill Houses book, How to Flip Real Estate Like a Killer. Clothing and apparel products. Say, if I want to sell the We Kill Houses Death to Houses t-shirts, that's what that class is for. The class is advertising, business, and retail services, such as the We Kill Houses firm. Education and entertainment services, such as the We Kill Houses educational course. And computer and software products and electrical and scientific products. The We Kill Houses downloadable How to Kill a House manual is an example of that. In conclusion, thanks for listening. Hope you learned about trademarks and how they can help you in your real estate business. Are you a real estate investor that needs a trademark? Consider contacting me, Attorney Brown Pendergraft, attorney for investors, and the holder of the trademark Planlord. And you can schedule a time for me to call you using www.bookme.name/attorney. That is my preferred way to contact real estate investors. Definitely use it. Really easy to use. You can follow me on social media at Pendergraft Firm. You can find me on YouTube. More videos like this one, youtube.com/Pendergraft Firm. You can also take a look at my Facebook group, Planlord, legal information for real estate investors. You can just type Planlord into your Facebook search to find it, or you can go to that link. And you can also check out my website, www.tpf.legal. This is where I post my my corresponding blog to this post, and I have plenty of other posts and videos you can check out going to www.tpf.legal. So read more about me, learn more about me. All right, thanks again. And again, you can download the slides to this presentation at tpf.legal/WeKillHouses. And again, thanks for watching.